Thank you for joining us today to discuss how to complete a health professional report in QCAT. My name is Claire Bassingthwaite. I'm the Deputy Chair of the Queensland Law Society Health and Disability Law Committee. I'm also Legal Team Manager of Professional Conduct at Avant Law. I'm joined today by Karen Williams. Karen is the Chair of the Queensland Law Society Health and Disability Law Committee and Principal Solicitor at Aged and Disability Advocacy Australia. We're also joined by Dr. Tony Bayliss, a medical practitioner and Fellow of the Royal Australian College of General Practitioners. So we're here today to discuss health professional reports for applications in Guardianship and Administration Matters in QCAT, which is the Queensland Civil and Administrative Tribunal. We'll be covering what a health professional report actually looks like, why it might be required, what matters the health professional might consider when assessing capacity, and how to complete the report and to return it to QCAT. On the slide, we have an example of the health professional report and what it actually looks like. And we'll go through the sections of the report later. So Karen, when as a legal practitioner might a client need to seek a report?
There could be numerous circumstances that a legal practitioner might start thinking about seeking a report from a health professional. Obviously, it's contingent around the issue of capacity and the person's ability to make their own decisions. And if often around perhaps issues of conflict, there might be disagreement between the attorney and the person about their ability to make decisions. There might be a need for a guardian if no one has made an enduring power of attorney. There's a range of issues that may lead to that, but it's often around an issue of declining cognitive ability or a young adult just turning 18 who may have had pre-existing disability.
And so the purpose of the health professional report in those types of matters, can you talk to us through a little bit about that?
The purpose of the health professional report is to give QCAT, provide evidence to the tribunal, so QCAT being the relevant tribunal, as to whether the person has decision-making ability and for what particular decisions. They're unable to make orders or appoint a decision maker if someone has the ability to make their own decisions. On the other side of that, the tribunal can make a declaration the person has capacity and they have no need for a decision maker. So it provides that clarity, so that is very important form of evidence for the tribunal to rely on in seeing whether they've got authority to make decisions for an adult.
So when you talk about making decisions, what are some of the types of decisions that we might be considering here?
Well, in guardianship, the decisions are fairly specified. So there's personal matters, that's lifestyle choices, where you live, what service providers you might have, who you want to have contact with. The special personal matters, which are less frequent, and they involve things around marriage, voting, making a will, and they're outside the scope of the tribunal. And there's health matters, which are a subset of personal matters. That's self-explanatory. Financial matters, which are pretty much all-encompassing, from bill paying to investments or property matters or legal issues relating to any of those decisions. And there's special health matters, which also are fairly unusual in terms of the tribunal having oversight, but involves matters such as sterilisation or abortion for someone with decision-making disabilities.
And we're talking about a health professional report. Who is a health professional in the context of this particular question? Is it limited to doctors, or is it open to other health professionals?
Well, it's open to other health professionals. However, people often feel, a lot more comforted and confident in the opinion of a doctor, and often GPs are well placed to have this initial consult around, and if the GP is not comfortable in providing a health professional report, they may make a referral to the relevant specialist.
Dr. Bayliss, did you have any comments about that professional relationship?
Yeah, well, I think there are several aspects to it. So the first one is obviously about the clinical qualifications, but there's also the longitudinal relationship between a patient and their GP that would help a GP to, make an appropriate assessment. GPs make assessments of competence every day, whether it's a driver's license or someone under the age of 18 seeking medical treatment. However, this obviously is a more formalised process, and I think as GPs we're probably a bit more circumspect about it because we do understand the significance of making these decisions. So I think while clinical matters are important, the relationship is fundamental to being able to make an appropriate and fair decision.
So in terms of requesting a health professional report, who can actually request one? Is it limited to the person about whom the information relates, or can other people request the report? And if it's other people, what are some of the privacy issues that might relate to the other people requesting the report? Because obviously the report's going to contain sensitive health information.
Yes, this is where something that's seemingly simple on the surface starts to get a bit more complicated. So the adult themselves, that's relatively straightforward. They may request a report to be able to assert to, overactive family members or friends that they're indeed able to make their own decisions, and they can request that, of their GP or the relevant health professional. However, in circumstances where people might think someone needs a level of protection or extra support for decision making, a family or friend, has standing to bring an application to QCAT, so they have that authority and therefore able to make a request. That makes it very difficult for, the health professional to consider the privacy aspects of that. So they're able to make that request, and then it's up to the health professional to determine if they'll, provide that information, do the assessment, do the report, and then who to provide the report to. That's a matter for the health professional representative or lawyer. That's easy for the health professional to ascertain that professional relationship. Attorney, guardian or administrator, once again, there's evidence of someone being an enduring power of attorney, that there's been enduring power of attorney document completed, that there's a guardian or administrator appointed. Once again, there's evidence about that relationship and a degree of comfort that relationship provides. And once again, a service provider might ask because they might be confused about decision-making arrangements for the person that they're providing services for, and they can verify that relationship, again, to the health professional. So, yeah, that's just an overview of some of the complexity.
So if the purpose of the health professional report is to assist the tribunal in making a decision about a person's decision-making capacity, can you talk us through the actual relevant legal test in relation to capacity?
Yeah, so the relevant legal test in relation to guardianship and administration matters is located within the Guardianship and Administration Act, unsurprisingly. So we're not talking about relevant legal test of capacity to make a will or to make other types of decisions outside of those types of matters that we described earlier. So it's a 3-limb test, and so if we just go forward, there we go. So the definition of capacity is up there on the screen. It's person needs to have understanding the nature and effect of decision about a matter. So they have to understand what the impact of the decision is. They need to know the options that are available to them. and they're making this choice freely and voluntarily. So that's it's their decision, in effect. They can be supported to make the decision, but it still has to be clear that it's their decision. They can communicate the decision in some way. It doesn't have to be verbally, it doesn't have to be in writing. It can be within their usual method of communication.
And what are some of the legal considerations when assessing capacity for decision making?
Well, firstly, it's applying the presumption of capacity. So once 18, and Tony mentioned that before, that once 18, we're all presumed to have capacity as adults. So that's even if you have a pre-existing condition or a diagnosis, at law, we're all assumed to have capacity. So we start from that basis. And it's essentially a legal test that's informed by medical and health professional information, and it's determined by the court or the tribunal.
Can you tell us about the health professional assessment that informs the report, which then informs the tribunal in making the decision?
The health professional assessment, so that's expert opinion by the relevant health provider, and essentially it's a functional assessment. So it might be driven by diagnosis or screening tests, etc., and various assessments that might be quite informative to the health professional and the tribunal. But it's how that impacts a person's ability to make particular decisions relevant to their life. And so the relevant, how does this condition, if a person has a condition or a diagnosis of a particular condition, how does that impact their ability to make healthcare decisions, lifestyle, accommodation decisions, financial decisions? And then we also touched briefly on restrictive practices, because that is also included in the legislation and the health professional report.
Can you explain what restrictive practices are?
Simply speaking, restrictive practices are actions that are taken to promote safety for the individual concerned. They can be in the form of chemical restraint, which is probably most important for the people that might be watching this webinar today. It can be environmental, restricting access to parts of buildings. It can be withdrawing access to unsafe implements that might ordinarily be in a kitchen, for example. It might be containment to certain areas. It might be seclusion to a particular room. The other complicating factor in terms of completing the health professional report is that in guardianship sector, there's restrictive practices in relation to people with a disability, which is a separate area to restrictive practices in relation to residential aged care. And so that's the legislation and protocols as they stand at the moment. Restrictive practices, as outlined in the health professional report, are only in relation to disability settings.
Excellent. Thanks for explaining that. Dr. Bayliss, can I ask you, from a medical practitioner perspective, what are some of the key principles of conducting a health professional assessment?
Yes, they'll very much depend on, on the context in which the patient, lives their life. So, indirectly, we look at the ability to make appointments and attend them, complete investigations, compliance with medications, a whole variety of, indirect factors. The assessment would then depend very much on the specific situation of the patient. So I think typically we're going to be seeing these decisions being made in the context of older patients. And so there are standardised, relatively common tests, such as the mini mental state exam, which can give you a degree of comfort as to someone's cognitive ability. That procedure is done in the rooms and takes about 20 minutes to do. So it's important when you're counselling your clients to try to help them to understand what's going to happen in the doctor's rooms. So certainly a 10-minute consult on a Friday is probably not a good time to get a thorough assessment done. There are other things that we can do, such as dementia assessments, which include excluding reversible causes, such as UTIs or thyroid dysfunction, doing CTs of brains. I have some patients who find humour when they get tested for syphilis, which is actually one of the differentials you need to exclude. But then you can have younger patients where we're doing similar assessments, and say people with profound developmental disorders, such as Down syndrome, where it's highly unlikely that they'd be able to have the ability to make their own decisions. And so sometimes it's quite clear, such as in the case of a patient with Down syndrome, but there are other times when there's a degree of subjectivity, and that requires, I guess, that longitudinal relationship with the patient, as well as specific assessments such as MMSEs and dementia screens that can also, I guess, get a narrower point that's more specific to that question for that patient.
In terms of claiming Medicare, as I understand it, this is not a Medicare rebatable consultation. Are there any tips or things that you can draw your colleagues' attention to that might assist in that regard?
Yeah, that's an excellent point to bring up. As GPs, we really try not to talk about money much, and I think that's kind of how it goes with a lot of different professions. The challenge is that if this is a report for medico-legal purposes, that's not the purpose of Medicare. Medicare is the treatment and assessment of patients. So a lot of the time, particularly with the over 75-year-olds, there is actually a 75-year-old health assessment, which would involve assessing a lot of these factors. So while if the assessment is being done purely for the report's purposes, it's unlikely that would be Medicare rebatable. But if a lot of that groundwork that will underpin that report has already been performed as part of a routine health assessment, then I could see a world in which that would be appropriate to at least bill the assessment rather than the bulk of the report to Medicare. But when in doubt, I think it's always appropriate to take advice from your indemnity provider. And certainly Avant, I'm sure, deals with these questions all the time. So, I think as a clinician, if there's any doubt, they should take advice. But, in and of itself, if the report is purely for QCAT's purposes, it's unlikely that it's a Medicare rebatable assessment or patient interaction.
And Karen, did you have anything further to add, particularly with reference to the capacity assessment checklist that is in the guidelines?
Yes, thanks, Claire. I think we've added the capacity assessment guidelines as a resource, toward the end, but in particular, there's 2 pages. If you're the type of person who does not want to read it from cover to cover, I draw your attention to pages 20 and 21. So the summary, the general test of capacity, and what's really important is there's a clarifying question that's asked: what is the decision to be made? So what's the immediate need? What is in front of this person that the challenge, be it in their health world, their social world, their care needs world, or financial world, or combination of all of the above. What's the decision or decisions to be made? And then unpacking all the different elements of the test of capacity, so understanding the nature and effect. So they outline what's involved in that and cause the clinician and perhaps anyone else to go through what's involved in understanding the nature and effect, freely and voluntary, communicating the decision. So really having a concentrated pause on that. And then the next page provides a checklist and once again focus on the decision to be made, identifying therefore there is a genuine need to assess capacity, that it's not just a bureaucratic or administrative requirement, because to have your capacity questioned is quite an emotionally vulnerable space to be in, and so that has to be respected, essentially. And then identifying concerns, applying the general test, help people prepare for the assessment, and provide any support. So if a person has any hearing loss or eyesight accommodations, any glasses, etc., that the assessment is conducted in a way that's it's going to be as positive an experience as possible, and giving the person involved the opportunity to ask questions and provide those answers and support, and then document the results of your assessment.
Excellent, thank you. Dr. Bayliss, for those health professionals who might not come across a health professional report on a regular basis, what are some practical tips for them in terms of maximising the adult's participation in their decision making?
Yeah, look, I think the first thing is being familiar with what's actually being asked is fundamental. And so I think it's important that clinicians don't feel pressured to complete the assessment until they're familiar with the assessment. So I think controlling some of the expectations for the patient and getting a clear timeline would be really good. I think supporting Karen's comments about supporting the decision-making process are really important. And one of the things we do see with some of our older patients can be literacy and numeracy issues as well. So making sure that you can find a way to meet the patient with the level that they're at. And I think the final one is understanding the context of the decision. What is the question that's being asked, and what is the answer that we need to give? And to combine all those things to provide an oversight. The term that was used before, I think, talked about it being an expert opinion. And when you've known someone and looked after them for the last 10 years, as a clinician, you are the expert in that person. We see people go through the seasons of life, and some of them are exciting and some of them are a bit sad, but understanding the patient and their trajectory and also the influences on them. It's an opportunity for us to make sure that our patient's not being coerced or manipulated into something that's not in their best interests. But on the other hand, too, it's also an opportunity for us to protect them from decisions that they otherwise would not make or situations that otherwise not find themselves in. So I think provided we're thorough, diligent and consistent, I think that's the best way we can look after our patients and help them to be cared for and supported.
So in terms of creating an environment for the patient in which to conduct this assessment that is supportive of the patient and meeting them, as you talked about, where they're at on their trajectory at that point in time, what are some ways to create that supportive environment for them? Dr. Bayliss?
Yeah, well, I think the first thing is setting them up to succeed. So having there with someone who they know and you know. I think having the assessment done first thing in the morning or at the best time for them. Obviously, avoiding emotionally distressing times. Bereavements are not the time to ask these questions, and if you can. I think giving patients time. If you rush people, you often won't get the truest assessment of them. So helping them to feel comfortable and able to take their time, and also knowing that sometimes these assessments might need to be split across more than one visit would be, something that you could think about to try to get the best out of your patient.
Karen, did you have anything that you wanted to add?
I think most of it's been covered, apart from cultural differences as well. So there may be need to organise an interpreter, and also take Tony's point is that people might have different levels of numeracy and literacy, and their education levels may differ a lot, and sometimes the tools or screening tools that are used, may not be suitable for people from different backgrounds.
And certainly there are some of the assessments in the mini mental state exam, or in addition to that, which are designed for patients who have literacy or numeracy challenges, which can be really good. And I think Karen's point about the cultural context is incredibly important. Coming from a Western European background, my worldview and my experience of the world is not necessarily the same as my patients. And I think being culturally sensitive and understanding that context is really important to making a fair representation or a fair assessment based on where that patient functionally is living their life.
Thank you. On the next slide, we've got a case study. It's a story of Amelia, who's an 82-year-old lady, and her challenges in terms of diminishing capacity and whether or not she can regain or has regained that capacity. We'll just let people watching this read through that at their own pace. Karen, what are some of the key takeaways from Amelia's story?
I think some of the key takeaways is that it's probably a reasonably common situation that Amelia is finding herself in that, and as we've sort of hinted at so far throughout this piece, is that capacity can fluctuate and can be quite dependent on short-term sort of health issues from which there's a recovery, and maybe longer-term underlying chronic conditions as well that there may not be a recovery. So, and this is often the situation where health professionals find themselves into how to sift through all of the, maybe one or two health conditions or more that are impacting on someone's ability. So it's a very grey area. It's not black and white. So having said that, there was a hospital admission, and at that time it looked like Amelia wasn't able to make decisions. She's recovered. She doesn't got concerns around decisions that the attorney may be making for her, and then it's, well, who's the decision maker? These are the decisions that are in front. And then, so how can lawyers and GPs work together to provide the right support for Amelia in this situation?
Thanks. And Dr. Bayliss, did you have anything that you wanted to add that arises in Amelia's story?
Yeah, look, I think the main thing I take away is very much consistent with Karen, and it's that what you see in a person at one point in time may not be their true level of functioning. When people have an intercurrent illness, particularly if they are quite frail, you can see a significant deterioration. And sometimes they get back to their baseline and sometimes they don't. So one of the challenges is how do we manage that time as they're in their convalescence? At what point is someone as good as they're going to get? Well, it's hard to tell. And I think it's important to be aware of those acute episodes that could adversely affect the quality of the assessment.
Thank you. So we've talked about some of the key principles behind the assessment, how to undertake an assessment, and what information is helpful in including in the report. I just wanted to delve into that a little bit more and talk about the importance of providing the whole picture, including perhaps limitations of the assessment. Karen, can you explain why it's important to include the whole picture within the report, given that it's going to the decision maker being the tribunal, including the limitations of the assessment?
Yes, it's very important, and some of the limitations, may be that, and Tony's already spoken about this, it could be the length of time you've known somebody. You may, be requested to do the report, and the circumstances surrounding a person's situation is that they don't have a long-standing healthcare provider or GP who's got that longitudinal perspective. So that's, going to be a limitation that, it's only a short-term knowledge of the person, so it's, within this time frame. It might be, the person has another health condition going on, so, a health professional report might be needed in a very timely way for QCAT's purposes, but it mightn't be the absolute best time for that individual. So those things can be noted. Any accessibility factors that you weren't able to access an interpreter for the particular dialect or language of that person is obviously a limiting factor. Tony also mentioned about the issue of bereavement. Once again, due to timing restrictions, a report may be required, but the person still may be suffering the effects of recent significant loss. So those sorts of things can be noted in your report.
Dr. Bayliss, did you have anything that you wanted to add in terms of the limitations and why it's important from the medical perspective or the clinical perspective to include those in the report?
Yeah, look, I think it's all very true. I've seen some patients who really decompensated in the context of bereavement with a long-term partner having passed. And on the one hand, it's been lovely to see that patient come out the other side of it. But if you were to assess that person at that time, you're not seeing them at their best. And so this is one of the challenges. I think as a clinician, our job isn't to prognosticate as to how someone will be in 6 months. I think our job is to put the facts on the table and let QCAT work it out. There are processes for that. It's natural as a GP to want to advocate for your patients. You like them, they like you. That's why you've got that relationship. But it's important to present the facts as fairly and squarely as you can, knowing that sometimes a decision may not be able to be made in the long term, and things will get revisited. And that's sometimes that's the best decision, to not make the decisions you don't have to until you do. But yeah, I think as a clinician, giving that context will help QCAT to understand what's going on in the broader broader life of the patient, so then they can help to provide clarity and guidance, so this person can live, the life with as much agency as is appropriate.
Thank you. So now, Karen, I just wanted to ask if you can take us briefly through the form so we can have a look at what it looks like, and any tips for completing it.
Thanks, Claire. So the form can be accessed from the QCAT website, and we've provided a current copy for you in this educational resource. So importantly, if you haven't done one of these forms before, the instructions for completing it at the final page at the end of the report. So the first part A is basic information. B is your, as a health professional, details and how you've known the person, how you usually see them interact with them. Is there a support person that's usually involved? Part C is the adult, so goes back to who's approached you to do the form, because that can be an important piece of information for the tribunal. So once again, it's about providing pieces of the puzzle to the tribunal who the ultimate decision maker is, and whether you've discussed the assessment in your report with the adult concerned. Medical conditions and medications, unremarkable, and whether any of those medications may have an impact on the person's behaviour or decision-making ability, also unremarkable, and you're asked for your opinion in relation to other factors that may impact besides their medical condition, such as family support or lack of support, non-compliance, those types of factors you may wish to reflect on there. Part D is just getting any sort of external mental health information in terms of any other orders that the person may be subject to, and also any other cognitive assessments. And we've already referred to the mini mental state or any other assessments or reports. You can attach those. and in particular reports in relation to capacity as well. Then decision making, you're asked to reflect on the various types of decisions: personal healthcare, lifestyle, accommodation, financial affairs, and whether the person's able to make these decisions freely and voluntarily, in your opinion. And there's also a question about whether, in your opinion, a person is being impacted negatively or positively from another person. So that's also a piece of the puzzle in relation to the capacity formulation. Part F goes to restrictive practices that we spoke about earlier. And once again, they only relate to restrictive practices as they exist in disability sector. Communication. So often in the general community, people get capacity and impaired communication, people with communication disability conflated or confused. So it's important to alert the tribunal if the person has any particular communication difficulties and how they would ordinarily communicate with you. Part H, we now sort of veer out of a clinical space and we go to enduring power of attorney, and they're all the elements that somebody needs to have capacity to make an enduring power of attorney. And then Part I is the summary, which is really important for the tribunal to look at in relation to person's ability to make healthcare, personal decisions, lifestyle accommodation and financial decisions, along with the use of restrictive practices, and whether they're complex or simple, and a simple decision is defined as a day-to-day decision. So that's the summary part. That's a key part for the tribunal, and along with any other overarching conditions that you believe that or person's been assessed as having, and other basic information is to be provided there, along with the signature and any other source of information that you've relied on for completing the report. So it may seem overwhelming. A good half of it is stuff at your fingertips already.
And Dr. Bayliss, do you have any comments for colleagues that might receive one of these reports, and it's a number of pages long? It no doubt would feel very overwhelming if they're not familiar with it. Any words of encouragement or support?
I think when you get given that stack of paper, I think the first thing is to take a breath, work out what it is that I need to do, what is it that I would like to do but can't do, and how do I approach that. And like I said, the main standard is your standard as a professional. We don't have to be medico-legal experts. We basically have to give the clinical information to the best of our ability and the best of our knowledge, and to make sure that whatever limitations there are on our assessment, that they're made, that they're clearly stated, so that the tribunal can assess them and I guess make their own opinions based on that, or their own assessment based on that.
Thank you. So in terms of the report, if we assume the assessment's been done, the report's now being completed, who does the report get given to? Do you have to give it to the adult? Can you give it to the adult about whom the report's been prepared? And what if you're in a situation where another one of those interested persons that we mentioned earlier has requested the report? Who do you give it to in those circumstances, Karen?
Yeah, so this could be a variable answer. So if adults requested it, you can give it to the adult because it's personal information to them. They might ask you, look, can you just send it straight to the tribunal? And we've got the details there of where you send it to. One of the key things about the report from an administrative point of view is if there's a QCAT application that you know about, is finding that G number, which will be, or the QCAT client number, which is on the front page of the health professional report, that request. So if that number's known, that will be a key way of joining up the report to the application, so you don't need to worry too much other than that. That can go straight to QCAT. If someone with authority, such as a guardian or administrator or an attorney, has asked for the report, that can be provided with them because they have the legal authority to receive that report. So there is that grey area about a personal friend who they're perfectly entitled to make an application to QCAT, based on their concerns about someone's decision-making ability and whether, they might be in need of protection in terms of concern about decisions others are making for them or decisions that the person themselves is making or not making. Certainly entitled to make that application, but you may decide to send the information to QCAT, give it to the person concerned.
Okay. If we talk about the situation or think about the situation that in which the vulnerable adult or the adult about whom the report is being prepared might find themselves where there's concerns the medical practitioner might have about the family member or friend perhaps who comes with them, and concerns that there's some sort of coercion or potential elder abuse or a potential abuse. What are some of the considerations or steps that a practitioner might take in those circumstances or be mindful of in those circumstances?
Is be mindful about who the ultimate beneficiary, may be for a set of circumstances. So, particularly in relation to the selling of, main assets such as family home or place of residence or moving people on or that type of thing. So be aware of various motivations of various parties. And once again, what can mitigate against that is having a long-term relationship and having that good long-term understanding of a person. So, but you may have concerns, and then, particularly if the demeanour of the person changes and that's not sort of clinically indicated, you can't find, a clear link. So you may ask questions, the person may or may not want to participate, so you may be left with sort of a concern. So sometimes, it's about acting in the least restrictive way possible because you've got the most protection and the steps intervening. So, asking the person if they've got enough support or if they thought about any extra services, because the beauty of that is that there's more people around that they can get to know and can access the person and see how things are going on a day-to-day basis. So that's the connection, if the person's over 65, through services with My Aged Care or NDIS. So that's sort of the lower end of the scale. And then, if you're noticing particular physical signs that, that's the higher end of the scale, where you might ask them if you feel, need to contact the police or the Office of the Public Guardian to make a complaint. And once again, the Public Guardian can receive anonymous complaints if at the end of the day you're concerned that this situation needs further investigation.
Thanks, Karen. Dr. Bayliss, did you have anything that you wanted to add in terms of advice or tips to colleagues who might have concerns about potential abuse of the person about whom the report is being prepared?
Yeah, look, I think Karen's given a really thorough answer to it. The only thing that I was thinking is maybe asking the person being assessed what they think about it. Obviously, it's pretty natural for people to want their own agency. That's a given. But yeah, you can often get a feeling for what someone thinks, whether they think it's fair or unfair, and then exploring that. And also their worries and concerns, and even the understanding of the process. So, look, it's a fiddly one, and I think it requires a little bit of I guess trying to connect dots and hoping you get the connections right.
Excellent. In terms of requesting a health professional report, Karen, can you give advice to any legal practitioners about how they can go about requesting it to ensure that they're giving the right information to the health professional and they're asking the right questions?
Yes, so I think providing, a short background statement as to the why this is being requested, the context of the person, so that as we've heard, the decisions that are in front of the person are the main reasons. So providing background as to those decisions, anything you know about the living situation of the person, that they recently moved, recently bereaved, they're now in supported accommodation, they live alone, they any of those things, are receiving home care services or supported home as it's now called. That type of thing gives an overview to the practitioner and gives them a head start into the context as to what this professional report is, if there's any what ultimately may be the ask of the tribunal application, that may need to seek an order, may need to propose, someone else has put an application in and the adult, would rather somebody else appointed, or it's just going to be driven by context. I'm sure that GPs don't want an essay on this, so it's writing it as shortly and to the point, but to help them starting addressing some of those key factors we've already spoken about in the health professional report.
Dr. Bayliss, did you have anything further to add if you're being briefed to provide a health assessment report or a health professional report that you would like to receive from the perhaps solicitor who's requested the report?
Yeah, look, I look at those features on slide 24, and it's an excellent summary. The main thing that I'd be looking for is controlling patients' expectations. What we want is everyone being on the same page, so we can give the fairest assessment. And I think certainly those issues are, I'd certainly be happy with that. If that's what all the legal practitioners can provide, that would be wonderful.
If I could just also add there that in terms of being very practical, if there's a date of hearing being determined, in the notice of hearing, that'd be excellent information in terms of timeliness and expectation management.
I'm sure health practitioners would very much appreciate that, knowing that. We do have some additional resources on the slides for people to refer to in terms of guardianship and administration matters involving the assessment of capacity. Before we wrap up, we've discussed a lot of information today, which we hope is helpful to both legal and medical practitioners alike. By way of summary, Karen, if you had to summarise in 2 or 3 key points that you would like, key takeaways that you'd like people to have from this seminar, what would be your top 2 or 3 points?
I think it's a reminder, and it's sort of been a subtext throughout, that this is a human rights jurisdiction and these are human rights matters, and the human rights that matters are the people about whom we're doing reports and filing applications, etc. And people want the greatest degree of autonomy and independence they possibly can to be their own decision makers for as long as they possibly can, and if that's not possible, to participate in decisions that impact their lives as much as possible. So that's key, and their involvement is key, and providing adequate and appropriate support is key, but in the way that's tailored that they find it supports them.
Dr. Bayliss, did you have any final key takeaways from today's for medical practitioners?
Well, yeah, look, I think even though the assessment isn't about the medical practitioner, it is a very anxiety-inducing procedure for the medical practitioner. We want to do the right thing. We're very conscious of the potential outcomes that this can have for our patients. And so certainly whatever we can do to, I guess, explain the context, both in terms of the clinical context and the legal context, but also the financial context for the patients would be really good. I think whenever you're assessing people's rights, we do need to be circumspect. And so whatever we can do to support the best decision being made, I think we should work towards.
Thank you both very much for your time and sharing your expertise with us today. I'd also like to thank the Queensland Law Society for supporting the development and publication of this seminar. I think it'll be very well received by both medical practitioners and legal practitioners alike. So thank you both for your time.